Any mention?
My lord, item 5, I am praying for 2 weeks time, my lord. I have informed the counsel for the respondent counsel also. Item 5, my lord, I am praying for 2 weeks.
Who is the other side?
We are there.
The Union of India, my lord.
It's not there. No?
Number 8.
Objection noted.
The request of the petitioner not objected to by the learned counsel for the hearing of the respondents. List of 2 weeks.
Please, Lordship. Lordship, I'd like to mention item number 29, Lordship. The senior counsel has already informed the other side, Lordship, about his difficulty.
Item 29.
Yes, Lordship.
You are appearing for?
The petitioner, Lordship.
Yes.
Of course,
There is some difficulty with the
AD
senior.
has informed me that it matter can be fixed on 8. I have no problem.
8th of May, Lordship, if it's possible.
Yes, 29 just
Should the same-
submitted by the learned counsel appearing for the parties. List this matter on 8th. 8th will be okay.
Lordship, the interim order may continue, Lordship, till next day.
The interim order first order shall continue till the next day.
Lordship.
My lord, item number 8, my lord. After 2 weeks, man.
2 weeks.
Why do you want 2 weeks, Mr.?
We'll have it next week, man.
What for you are asking time in this matter? See,
My lord,
this
there are
matter has been
certain-
repeatedly argued, and every time what is the thing?
My lord, this was, my lord, finally heard also, my lord.
Have you given a written gist of your argument?
No, my lord.
So now by now this court must have forgotten it. This is a problem. You are supposed to prepare a note. You have to give these things.
Exactly.
Yes, Mr. Karmi.
Yes, next week.
This
Obliged.
too also, as a joint request to the parties. List of 12 week.
No pledge.
May I please, Your Lordship? I beg to mention item number 24. Item number 24, Your Lordship.
24.
Yes, Lordship. The Archival Council is on leave, Your Lordship. Kindly have this matter after 2 weeks.
Your Lordship, in this matter, so many adjournments have been.
Was it the matter which was hard? This also was hard, Mr.
This was also hard. And they were to supply only some judgment which shows that.
Probably the respondent was not hard, I think. Is it?
Yes, respondents are not.
Anyway, see what to do. He's on leave. Okay, just after 2 weeks.
Similar brief for item 12, Your Lordship.
Wait, just a minute. This 24, let us finish first. 2 weeks at the request made on behalf of the respondent number. Your respondent number?
2, Your Lordship.
24.
24, I'm respondent number 2.
Yes. Okay. Yes.
Similar brief for item number 12, Your Lordship. It's a joint request, Your Lordship.
Well, I'm for the respondent corporation here.
No objection.
No objection, my lord. State.
You are making a request on behalf of?
Petitioner, my lord.
On the petition, on behalf of the petitioner.
My lord, this will be a joint request, my lord.
Yes, sir. When do you want it?
My lord, after 2 weeks. 2 weeks, my lord.
At the joint request made with the parties, list after 2 weeks. Yes.
My lord, item 14, my lord.
Yes.
My lord,
What happened?
my lord, some personal difficulties. Some personal difficulties.
Objection noted.
For 2 weeks. 2 weeks. At the request of the request made in- Yes.
My lord, item number 26. The conducting counsel is unable to appear before this honorable court as he is suffering. So this matter may kindly be taken up on the 2nd of May.
We'll have it after 2 weeks.
Highly obliged, my lord.
Yes, sir. With the request made by Mr. So-and-so on behalf of the appellant. Let the counsel appear on behalf of Mr. Where is Mr. Chakrabarti? Where? You're appearing on behalf of whom?
On behalf of the petitioner.
Petitioner. It's a criminal appeal, isn't it?
Yes, Your Honor.
Then it's appellant.
Appellant.
Yes, you are there. You are advocate on record.
No, my lord.
Then
I'm appearing on behalf of the conducting counsel,
who is the conducting counsel?
Lalraman Nangsanga.
Just Mr. So and so appearing on behalf of Mr. So. Okay. Landed counsel is appellant. Oh, on prayer made by Mr. So and so. Landed counsel appearing on behalf of Mr. So and so. Counsel appearing for the appellant. This is matter after 2 weeks. Yes.
Replay, Your Lordship.
And acknowledged, my lord.
May it please your lordship. Your lordship, I beg to mention item number 11, your lordship. I humbly pray your lordship kindly this matter may be listed after 2 weeks, your lordship. We have already informed the opposite party also, your lordship.
Who is the opposite party here?
It's GHADC, lordship. And one private respondent is there.
Nobody is appearing.
Lordship, we have already informed, your lordship.
If you inform that, does it mean that the party will not appear?
Lordship.
If parties mutually decide something outside, so they are not required to be present before the court. Can it be the position, or the court is too liberal in giving adjournments?
Lordship, let it come then, your lordship, after some time. We have already informed.
This is item 11.
Lordship, it is 11.
Who is the counsel?
Lordship,
Who is the
the
counsel?
conducting counsel is Mr. A.G. Moman. He's having some personal difficulty, your lordship.
appearing? But then make sure, see, your whatever your arrangement outside,
Lordship,
the counsel should be present.
lordship.
Let's say with the request meet. And we have the petitioner list after 2 weeks. Yes.
Hello, lordship.
My lord, I beg to make a mention of item 6, my lord, if it is kindly listed next week, my lord.
I have no objection.
In item 6, you were there?
Yes, Your Lordship. On behalf of Ms. B. Karanlang, Your Lordship.
Yes, the request made on behalf of the state respondent and not objected to by the Lana Council of the petitioner. Please take it 2 weeks. Yes.
May it please your lordship. Your lordship, I beg to mention item number 28 of the hearing list.
28.
Yes, your lordship. Your lordship, if the matter may come up after 2 weeks, your lordship.
No objection, your lordship.
28, 2 weeks. At the request of the petitioner. Yes.
Much obliged, your lordship.
My lord, I'd like to mention item number 20, my lord. I am for 1, 2, 3. That's one number 1, 2, 3, my lord.
Yes.
If this matter can come up after 2 weeks, my lord.
20 is the request made on behalf of the respondent number so and so. List after 2 weeks. Yes.
Apologies.
May I please, your lordship? Your lordship, I beg to mention item number 9. I pray for some time, your lordship. This similar matter is pending for the division bench, your lordship.
What is this matter about?
In this matter, lordship, the respondent number 4 was the aim of Langren's aimship. Particularly in this matter, there was a complaint against him. There was an inquiry, but he was being absolved from all his charges. So against the inquiry report, they filed this instant petition.
Who is he? What is his status? Who is he?
His status is he's one
subjects of the aimship.
HEMA, lordship. He's one of the subjects of the HEMA.
One of the subjects of the HEMA means like he's a resident.
He is a resident.
Is he of which bearer somewhere?
And I think they are the complainants, my lord. Because they have filed a complaint.
They are the complainant.
Yes.
So he has locus standi.
Yes.
And
Now, this particular aim, lordship, he has been
Suspended,
suspended again. So this pertains to the first suspension.
so the matter has not become infructuous then.
No, no, this matter, they have challenged the suspension order, wherein this other single judge has
So what
dismissed
issues pending before division bench then?
the writ
That
appeal.
pertained, Lordship, after I was suspended again for the second time, I had approached this honorable court, Lordship. So I challenged my suspension order. So it was dismissed, Lordship. Then we had filed an appeal.
That has reached division.
Yes.
That is pertains to the second suspension.
That is okay, but then which way that will have a bearing? This is only concerning the inquiry.
Lordship.
Where you were.
Petitioner is seeking.
There's some bearing by two issues raised by the respondent. They say that before placing the chief, the complaint should go before the third part, not directly to the district council. They've taken that plea in that case. So Ranit's bench, a single bench, decided overruling that contention. And being agreed with that, matter pending before the division bench. In this case also, my lord, similar plea they have taken.
Which way the decision of the division bench will have a bearing in this matter?
My lord, here in this present case also, they have taken the same plea. That before placing him under suspension, complaint lodged by the resident should go to the third part headed by him. Now what happened, the complaint was lodged to the district council directly. On that basis, inquiry was conducted and the inquiry report was furnished, and inquiry report was not given to complainant also, and he was reinstated.
Okay, that is all right. Your grievance is against the inquiry, outcome of the inquiry, isn't it? And that is what you are challenging here.
Yes.
But then
his reinstatement will have challenged.
The thing is that the person against whom you are making this challenge, he is no more in the office. So is it not that this matter becomes infructuous?
My lord, in case if he succeeds in the division bench,
then only you will have.
Then only.
And if
Then-
he fails, then matter will
Yes.
come to an end.
Yes,
So
therefore,
that way the matter will have a bearing.
yes, because of it we sought for some time.
So has it been this thing recorded by this court that there is a corrected matter pending before division? No.
Yes, lordships, can they have ordered it?
Anyway, just as prayed for by the
26/7.
parties, Direct Council appeal of the parties. List this matter after when I'll have after 3 weeks.
After 2 weeks.
After 2 weeks, my lord.
Yes.
Give it a touch.
I'd like to mention item 27 now.
Yes.
This is a quashing petition, my lord, for an offence under POCSO Act, my lord. Basically, my lord, the connected issue is pending before the Honorable Division Bench, my lord.
Romantic relationship.
Right. my lord. Marriage, in my case, it is a marriage.
Okay, marriage, romantic. There cannot be marriage without romantic relationship. Okay, yes, sir. Yes, sir, the request to the petition list after 4 weeks. We'll have it 4 weeks. You are there in 27.
Yes, Your Honor.
27 you are appearing for?
Respondent number 3, Your Honor.
That's number 3. And who is appearing for the state?
State.
This is the problem, Mr. Gurung. This most of the cases now, yesterday also 2-3 matters. Nobody appeared. So if that be the thing, then court will record it and pass an order and forward it to the law department. Once you have a panel, should not go unrepresented.
My lord.
Anyway, just list after 4 weeks. Yes.
my lord.
My lord, I'd like to mention item number 23, my lord. It's a similar matter, my lord, quashing of the POCSO proceedings. This
Okay,
matter also
this,
may be.
this is also the request made by so and so, list after 4 weeks. Yes.
My lord, item number 16, my lord. In this matter, my lord, I've been recently appointed as a legal aid counsel, my lord. So I just received the copies of the petition. I need some time to prepare the matter, my lord. Maybe she may fix it after 2 weeks, my lord.
Item 16.
My lord.
Oh, you've been appointed as a legal aid counsel.
Legal aid counsel.
Is a service matter?
Service matter.
Even in service matter also legal aid is provided.
My lord.
But then you have already entered appearance. Your name is
My
there.
lord, my lord. On the last occasion, my lord.
Yes.
Entered appearance.
Yes, sir. This also, sir. When, who is appearing for the respondent here? Yes, Dr. Mojigo. No.
After 2 weeks, my lord.
Okay. This also seat 16, just the request made by so and so. She'll come as a legal aid counsel. This is matter after 2 weeks. Yes.
God bless.
May it please, Your Lordship. I beg to mention item number 7. Let the matter may come up after 2 weeks, Your Lordship.
Why?
We
Why after 2 weeks?
are not ready, Your Lordship. Give us some more time. We are not ready to.
You are appearing for?
Respondent
Private respondent.
yes. 3 and 4.
What's the matter about, Mitra?
This is regarding the service matter, Your Lordship, where I have suspended. There was no proceeding, departmental proceeding against me. Just suspended.
Why private respondent is there?
Because in my place they have appointed a private respondent after suspending.
After suspending?
Yes, they have suspended me. Thereafter,
So what is your present status? You are still under suspension, or you have been dismissed from service now?
They have not dismissed. There is no even departmental proceeding against me. They just
So your status is a suspended employee.
Yes.
And are you getting subsistence allowed?
Earlier, they, because of this court order, we
present
got,
you are-
but now at present we are not getting.
You are not getting.
Not getting.
You are the state.
For the state, yes.
Is formal party?
Formal party, initially we are the main respondent, but this municipal board has taken over. With the petition was working in the municipal.
He's an employee of municipal board. Tura municipal board.
Bakmora municipal board.
Okay. Say 2 weeks at the request period. On request meet. By Learned Counsel. Appearing for the son of so command not objected to the Learned Counsel for the petition list after 2 weeks. Yes.
How do you oblige, Your Lordship?
Much less lordship.
My lord, here, item number 13, my lord, this matter was heard at length. Now we were instructed to exchange our written argument, bullet points, my lord. So I'll do that in course of the day, my lord.
The judgment, citation.
Yeah, that's
Yes.
a week time, my lord. In the course of the day, I'll be exchanging.
Oh, there is. This is a criminal appeal.
My lord.
And it was heard.
It was heard, my lord. From the appellant side, my lord. I'm here to start.
Okay. When shall we have it?
Your Lordship, 1 week.
That will be all right for you?
Yes, ma'am.
This is a criminal appeal. Just on joint request made by the parties. This is matter after 1 week. After 1 week.
Much obliged.
Deploy.
Your Lordship, I beg to make a mention of item number 10. Your Lordship, the conducting counsel for the matter is unwell. If the matter may kindly be taken up on the 28th of April.
We will not give you a specific date. We'll have it after. This is what it is. After a week.
Okay.
No. After a week, at the request meet. On behalf of the petition. Yes.
Oblige you.
Supplementary cost list, item number 1.
Yes.
May it please Your Lordship, this is an application under Section 482 of the Criminal Procedure Code 1973 for quashing of FIR dated 16/6/2017 in GR case number 1112.
2017 FIR. You are
Yes.
seeking quash.
Yes, my lord.
Quashment after 7-8 years. Yes, please.
In GR case number 112 of 2019 and the entire proceedings and the impugned order dated 19/3/2025 passed by the Judicial Magistrate First Class at Shillong, Your Lordship. Your Lordship, the brief fact of the case, Lordship, that the Director of Corporation of India Limited, one of the public sector undertaking, was engaged in installing physical backbone for National Optical Fiber Network, and the contract work was allotted to the petitioner, Your Lordship. That is the accused number 2 in the GR case, on the basis of a tender notice dated 13/09/2014. My lord, the tender agreement is at page 21, annexure 1.
Yes.
Your Lordship, page 23, Your Lordship.
Yes.
Your Lordship, there is a specific portion of work included, a component described as the excavation of trenches and laying of optical fiber cables
We are
to duct.
reading which part?
Your Lordship, it's para 2, Your Lordship. Excavation of para 2 in page 23.
There are two in page 23, yes.
Excavation of trenches and laying of optical fiber cables through ducts, testing, commissioning, and maintenance of optical fiber cables in 11 blocks of 3 district Meghalaya and 6 blocks of 3 district Mizoram by Redtel on behalf of Bharat Broadband Network Limited.
Yes. And you have been allotted all those works?
Yes, yes.
All the works?
In the village of Mauplang, Your Lordship.
So not all the works which are mentioned in the tabulation.
Yes.
Which is your serial number? Where?
Serial number 2.
Moflong is here.
Yes, yes.
This has been allotted to you.
Yes, yes.
Okay.
Your Lordship, I respectfully submit that there is different portion of terrain would vary in terms of rock or soil structure and therefore would require different amount of work to be done for the purpose of excavation.
But this all were not stipulated in the work. It was in the contract.
Yes,
It was stipulated.
Your Lordship.
Yes.
And Lordship, there are several letters of acceptance, Your Lordship. Letter of acceptance of amendment till the final amendment, Your Lordship, as per the schedules of work and rates, Your Lordship. That is in
Now,
page.
what you have referred just now
Yes,
is a tender document, isn't
yes,
it?
yes, Your Lordship, yes.
Okay. Now you took part in the tender.
Yes, yes.
Then your bid was accepted.
Yes, yes.
And then
And Your Lordship.
letter of offer was made to you.
Yes, yes, Your Lordship. While the work was being carried on, Your Lordship, an FIR dated 16.
No, whether there was an execution of agreement.
Yes, Your Lordship.
So you executed agreement also.
Yes, yes.
So this is not a contract related dispute. The present case is not a contract related dispute,
no,
isn't
no,
it? Okay. So then you resumed your work.
Yes, yes,
Okay. Then what happened?
And Lordship, FIR dated 16/06/2017 was forwarded to the Special Judge Meghalaya Shillong, Your Lordship, by the head of branch CBI.
Who was the FIR?
Your Lordship.
And for what purpose? What is the reason for filing FIR?
Your Lordship, 241 is the FIR, Your Lordship.
Page?
Page 235, annexure 15, Your Lordship.
This is a forwarding
Yes, yes, Your Lordship.
of FIR by CBI.
Yes, Your Lordship.
Yes.
Your Lordship, may I read the FIR, Your Lordship? This forwarding FIR.
Yes. What is the part? What is the allegation? Where is the allegation against you?
May I read the FIR? I am forwarding herewith original FIR of CBI case number RC 0202017002 dated 16/6/2017 registered against Shambor Kharkongor A1 Joint General Manager Retail Corporation of India Shillong Shri Subarta Bhumik A2 Manager Retail Corporation of India Shillong Shri Kitborlang Kurba A3 Project Engineer in charge of Mauplang Block Retail Corporation of India Shillong Contractual. The accused contractor Shri Renol Nongse A4 and the unknown others under section.
You are Renol Nongse.
Yes, yes. Under section 120B 420B IPC and section 13.2 read with section 13.1 clause 1 subclause D of PC Act 1988. Your Lordship, the allegation as per the prosecution was inflicted bills were submitted by the contractor, by the petitioner.
Inflated.
Yes, yes. For works that was strongly classified, Your Lordship.
Where is that allegation? Who lost this FIR?
CBI, madam. CBI.
That is forwarding by CBI. But then
Kindly come to page 24, madam.
Your Lordship, there was
just
Your Lordship, there was no information given on. It was given on oral, no signature or thumb imprint, Your Lordship. There was no source, Your Lordship.
No, who lost this FIR against you?
Your Lordship, if we come
It was
to
this was a suo motu registration by CBI.
on
Or
the
who informed
information,
CBI?
if you come to page 238, Your Lordship, serial number 6, complainant informant.
Yes.
It has stated source, Your Lordship. It has reflected as source.
Source. Is it written source?
Yes, yes.
So it was a CBI. Yes. This is the allotment of contract is by the state
By the
department, department under the state government.
It's not by some private enterprise. In fraud.
Can CBI directly suo motu register, or there was a general consent by the
Railways, my lord.
Hmm?
It appears Ministry of Railways.
Ministry of Railways? Okay. So it's concerning center.
Yes, ma'am.
Yes. Yes. Okay.
Page 21, my lord. Annex
Yes. Okay.
Mm.
Yes.
Your Lordship, if you come to letter 15/5/2018, Your Lordship, that is an extra 11, Your Lordship, page 228, Your Lordship.
Page
228.
Yes, 228.
Your Lordship, if we come to the letter, Your Lordship, at the last line, Your Lordship, we can see that the total recovery made rupees 65 lakh 6,638, which is included recoveries under order SOR items over and above the recovery of rupees 56 lakhs 1,130. Your Lordship, I respectfully submit that the amount was recovered, Your Lordship.
When the amount was recovered?
Your Lordship, this letter is dated 15/5/2018.
So after the FIR was lost,
Yes,
isn't
Your
it?
Lordship, yes.
So with this
Yes.
recovery,
Your Lordship, the investigation was carried out and a charge sheet has been filed, Your Lordship. Charge sheet is in at page 246.
you have not challenged this recovery. It stands. There is no challenge of this recovery. You have not disputed that recovery part, isn't it?
Your Lordship.
So far as the amount which was required from you, you never disputed it.
My Lord, if you come to the charge sheet, my Lord, that is in at page 246,
Just a
Annexure
minute, just a minute,
16.
just a minute, just hold on. So this shows that good amount of money has been recovered, isn't it?
Yes, yes, Your Lord.
That is not what you are exactly pointed out. This is these are details, the entire issues. This whatever
Your Lordship,
is
as per
described
the
from
tender.
paragraph A to paragraph H, all amount are this thing recovered from you. It is not only H. You see the first paragraph of the letter. Retention money is a security deposit. Yes. It is to the tune of 56 lakhs 1,130, isn't it? Over and above recovery of so and so. So total recovery made is rupees 65 lakhs 06,000 so and so, isn't it? Okay. Okay.
Hmm. Your Lordship, during the investigation, charge sheet was filed, Your Lordship. Charge sheet is at page 246, annexure 16.
246.
Yes, Your Lordship, page 246.
Yes.
Your Lordship, we can see that in serial number 4 IPC, we can see that 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 section under the Prevention of Corruption Act were dropped, Your Lordship.
Yes. Only 120B, 420, and 511
Yes, yes,
IPC remained. Yes.
Your Lordship, during the trial, Lordship, the petitioner had filed an application under section 239 CRPC for discharge after hearing. Your Lordship, we argued for consideration before charge under section 239 CRPC, Your Lordship. And Your Lordship, the learned judicial magistrate first class dismissed our application, Your Lordship, observing that Your Lordship, annexure 21 at page 341 is the impugned order, Your Lordship. My Lord, the operative paragraph is at page 44.
Page? Page? 3?
Page 350.
350. Yes.
May I read, Your Lordship? Paragraph 44. Therefore, the application of discharge filed by the accused person number 1 and accused number 2 does not succeed. This is sufficient basis to proceed to frame charge under section 420 in IPC and 120B IPC as against Renal Northgate, and to frame charge under section 120B IPC and in the alternative section 107 IPC as against Kitborlang Kurba. Your Lordship, I respectfully submit that, Your Lordship, that the FIR dated 16/6/2017 is premature, Your Lordship.
Why premature?
Your Lordship, there is a completion certificate dated 4/10/2021, which was issued for us, Your Lordship, which clearly stated that it is all certified that the performance of the agency is satisfactory, Your Lordship. If we come
what is the allegation against you in the charge sheet? Take us to those parts. The allegation.
420.
The allegation, the gist of the allegation, not the sections. Where it is stated. And what is the ground you have? This is an order passed by the judicial magistrate first class.
Yes, yes.
So why you are here?
Your Lordship, for quashing the FIR.
That is okay. Why 482? You have other remedy available. If you are challenging the order of discharge, it's not that you have some other remedy available.
My Lord, the CBI doesn't have any jurisdiction, Your Lordship. If you come to page 222, Your Lordship.
Page
222.
222.
Oh, sorry, Your Lordship. 322. 322.
Yes.
May I read, Your Lordship? This is a notification dated 28 April 1989, Your Lordship. May I read, Your Lordship? In pursuance of the provision of Section 6 of Delhi Special Police Establishment Act 1946, Act number 25 of 1946, the Governor of Meghalaya hereby consent to the extension of powers and jurisdiction of all members of the Delhi Special Police Establishment to the state of Meghalaya for investigation offences as indicated hereunder. Clause A, offences under Prevention of Corruption Act 1988, Act number 49 of 1986. Your Lordship, if we come to the charge sheet, Your Lordship, the section which is stated in the FIR was dropped in the charge sheet regarding Prevention of Corruption Act, Your Lordship.
That is okay, but then B remains. Suppose B remains.
Your Lordship, if there was any dispute, it should settle as per the tender agreement, Your Lordship.
See, read that surplus to attempts, abatements, and conspiracies in relation or in connection with one or more of the offences mentioned above, and any other offences or offences committed in the course of the same transaction arising of the same offence. So that takes care of this thing. So,
my lord, if you come to page 112, Your Lordship, there is a
who is appearing for CBI?
Madam, notice has to go. I appear for responding one only, madam.
We will issue notice. Nothing more than that.
Your Lordship, I pray that
You have not made out a case for any interim order.
Your Lordship, there is a similar case, Your Lordship, passed by this Honorable High Court, Your Lordship, and it was upheld by the Honorable Supreme Court, Your Lordship.
What is that case?
Similar. Regarding jurisdiction of the CBI, Your Lordship.
Yes. What is that? Yes, Dr. Mujiga is appearing for CBI.
My lord.
Hmm?
Senior counsel do appear, madam.
Yes, what do you want to show here?
Your Lordship, if we come to para 31, Your Lordship.
Para?
Para 31, page 14.
Para 31, yes.
Analysis of the case of the parties herein and observation made above, this court would prefer to the case of State Haryana and others versus Bhajanlar and others 1992, wherein the Honorable Supreme Court categorizing instances or illustration within which the inherent powers of the High Court under 482 can be exercised on such instant being para 102 Clause 1, this court applying the principle therein is convinced that the petitioner had made out a case of his prayer to be allowed. The said paragraph read as follows. Where the allegation made in first information report or the complaint, even if they are taken at the face value and accepted in their entirety, do not prima facie constitute any offence to make out a case against the accused. In the light of the above, this petition is hereby allowed the FIR dated 10/12/2015 filed by the head of branch CBI ACB Shillong and the related proceeding in CR case number S of 2017 before the Court of the Learned Chief Judicial Magistrate Shillong are hereby set aside and quashed.
This judgment doesn't cover your case.
Yes.
But my lord, if there was,
it is not your case here that the allegation made in the FIR does not make out any offence. It is only on that. See, basing on that proposition of law in Bhajanlal's case. Now, you have to first show the court, take this court to the FIR and the charge sheet, and then you say that even those allegations made accepted in total, then no case would be made out against you. Then only. This is what this judgment speaks about. If you are taking shelter of this judgment, that is nothing more than that. We'll issue notice, madam. We'll just see. Let the other side appear. Hard. MS. ADCM. You are appearing for?
Madam, respondent number 1, madam. State.
Learned Counsel appearing for the issue notice. Returnable in 3 weeks. MSR Colony. Learned GA or APP or what?
GA, madam.
appears for the respondent number 1. Stop. The petitioner shall take steps for service of notice upon the respondent number 2 within 2 days. Least after 3 weeks.
Your Lordship would be pleased to stay, Your Lordship, the proceedings in GR.
You have not made out a case for sitting. Just say prayer for the interim prayer will be considered on the returnable date. We'll keep it open for the next day. You come prepared with these things. You just, since you are taking shelter of the judgment passed by the coordinate bench, then confine to these things and just satisfy us that even we accept the allegation made in the FIR, no offence will be made out of this. If you can show that, that will be.
Item number 2. Item number 1.
Yes.
Yes, Lordship, this is the application for restoration of the petition, which was dismissed for default. And then the petitioner, the applicant here, have come after some delay was there, Your Lordship. Therefore, the private respondent have filed an objection, saying that it's not be condoned. But otherwise,
delay of how many days?
Actually, as per the my calculation, the delay was only 400, around 400 days.
899 days.
899 days as per order dated 25/6/24 by this honorable court.
That is the correct.
That is the number of days, Lordship.
You are not
899.
disputing that period.
Lordship, that is not disputed, Lordship.
Yes. So what is the subject matter of the writ? What is the issue involved in the writ petition?
Issue involved, this is actually particularly regarding Nokmasip account, where I was appointed as a Nokmasip, and since from 1995, the EM has passed an order in my favor, and that order was never challenged, and that order was never set aside, neither challenged any other court. And basis of that order of 1985 order, I was existing as a Nokma successor Nokma.
So that is a
that was
Nokmaship.
yes, that is the merit of the case.
Just a minute, you do not have to go that far.
Yes.
Just tell us the issue involved. That is a Nokmaship. The dispute with regard to Nokmaship.
Yes, Lordship. Now issue here, yes, the issue, the reason for the delay is because
who is appearing for the private respondents here? The state may not have that. Yes. So you have filed an objection to the prayer. The state may.
State is not filing objection, Lordship.
Council
State is
also
only a
have not
foreign
filed.
party.
Lordship.
I'm for respondent.
District Council.
Yes, well, I am there.
You have filed.
No, my lord, we are not objecting to that miss case.
Yes.
Yes, Lordship.
Now see, this is very surprising. Your petition on the, so far as the cost title is concerned, it's 899 days. Paragraph 1 of your petition says 491 days.
No, no. Actually, it is Dr. was there, but that was excluded entire amount. There was a COVID period, Your Lordship. Some days was
So
excluded.
if those period you say, if according to you is exempted, you do not have to seek condemnation. You have to say only this period.
Yes, now exact delay was only 400. That's why I'm saying, Your Lordship, I have make a statement, Your Lordship, that
Yes,
it was-
so we are
it was
ready. We
only
can.
491 days excluding. That is the entire, including the COVID period, everything that was 890 days, and excluding those COVID period, I have only 491 days, Lordship. I have stated in the
Excluding the covered period, according to you, that should be
yes,
491.
491.
Wait.
491 days.
Do not make things complicated. Try to make the court understand in
Yes.
simple language. This court doesn't understand the things if it is make complicated.
Yes, Lordship.
Actual delay is
491 days, Lordship.
no. What is the total delay?
Doctor,
Is
delay, my lord.
819 days,
Yes.
isn't it?
Yes, Lordship.
Okay. Now actual delay is
491 days.
490. This is minus this covered period.
Yes.
When is the exemption for covered? From which time? For how many days?
Exempted
Total period?
yes, Lordship. It was from effect from 15 March 2000 15 March 2020 22 till 28
15 March
15 March 15 3 2020 till 28/02 2022.
28/02/2022.
Lordship.
How many days altogether?
Altogether, which is equal to 715 days. In 715 days.
This is the exempted period.
Yes, Lordship.
So from 899, if 700 is made, it is deducted, then how much remains? Then it cannot be.
Now
actual delay, cannot be.
remaining is 400.
This comes to 700 and how much? This is
715 days, which was for excluding period, which is equal to 715 days.
Yes. Now, according to you, what is the period of delay?
Period of delay, Lordship, that I've said that is 491 days.
So that is what according to you is
That is
491.
according to me, excluding excluding the exempted period of the COVID.
Excluding that period of 715 days.
Yes.
How can it be?
Yeah, in my para 24, I have explained, Your Lordship.
Very confusing, Mr. Sangma.
Para 24 of my just 1, 2, 3 I have elaborately stated, Lordship.
Para?
It is paragraph 24. I have make it para 1, 2, 3, Lordship. There I have stated the specific date how I have calculated. Made it, Lordship. Para 24, page 9, Lordship. That humble applicant petitioners also beg to explain the period of delay in specific manner as follows, Lordship. That from the dismissal of repetition, that is repetition number 103 of 2017 till the filing of MCWPC 181 of 2023, there was a delay of 898 days. That is the repetition of
Your writ petition was dismissed on which date?
my repetition was dismiss, your lordship, is on the. It's there. That is on
1/2/2021.
2, yes, 20.
1/2/2021.
Lordship.
That is during the period of COVID, when the restriction was on.
Yes.
Yes. Then what happened?
Then the ground for delay also.
When did you file this restoration application? Application for continuation of delay?
This
along with
this
application
one
for-
is on the 21 June 2024. Earlier I have filed it, but due to some technical difficulties, I withdraw again. I have filed it. That also I have mentioned here. But then, your lordship, that
This present application was filed on 21/6.
yes, 21/6 2024.
Yes.
The ground I have stated, your lordship, is in para 24 and the 25 of my petition. The delay is not intentional. Actually, the petitioner had been diligently pursuing, but due to some miscommunication between the.
But then what you are submitting and what you have averred in your petition are totally different.
No, they just
read 24.
Yes, that is
one.
the explained. Yes, that delay. Yes, explains how that sequence.
Huh?
Yes, lordship. Let me just read it.
According to
yeah.
you, the restoration application should have been filed in 30 days.
Yes.
That means by 1/3/2021.
Yes.
But the applicant filed his application on 18/8/2023 after the delay of 890.
Yes, lordship.
So
then second, I have said that
you are
from the date.
contradicting your own
Yes,
stand.
no, lordship. I'm sorry, lordship. Yes.
Why? It's not a matter of sorry or not sorry, Mr. Sangma. We are conducting a court proceeding, isn't it?
Exactly,
So we have
lordship.
to go by the stand which you take. Yes. Then
Now I just made a para I said that from the date of filing of MCWPC number 181 of 2023 till the withdrawal of MCWPC number 181 of 2023, there was a delay of 238 days. That is, application for restoration was filed on 18/08/2023 and which was withdrawn on 12/04/2024. From the date of withdrawal of the application for restoration till the filing.
Just a minute. Let us understand.
Yes.
You filed an application in 2023.
Yes, lordship.
For restoration.
Yes.
And since there is some defect, you withdraw it.
Yeah, withdraw. Then again file this press petition.
And that is also after 238 days.
Yes, Lord, because that delay was that it is in during the pendency of the case, not because of this. Otherwise, lordship, there is that limitation act 14 will applicable in my case, because
if limitation act 14, if you say that is exempted, then you should not have brought it here. You are not required to file any application also.
No,
You are
only
going to say that this period will be exempted.
Yes, lordship.
Yes, then.
Yes, that what I'm trying to, yes, lordship, yes, that 230 days should have been as per that section 14 should be exempted. Then the number 3, my lord, that from the date of withdrawal of the application for restoration till the filing of the instant application for restoration, there was a delay of 70 days. That is to say that application for restoration was withdrawn on 12/4/2024 and the instant fresh application for restoration was filed on 21/06/2024. Therefore, the actual delay was 1,206 days, but excluding the period of with effect from 15/03.
Mr. Sangma, you please prepare a different chart. This has become a puzzle for the court. This has become total puzzle for the court.
At least my friend can withdraw and file afresh.
How many times you will withdraw, Mr. See, this is we do not know. This is I do not know which way I made a narration. It is utterly confusing. I do not know which way you are understanding.
In the course title, he sought continuation of 518 days.
Can you explain this? What is sought to be stated?
It is
Mr. Sangrejo?
difficult.
though it is not your job.
Yes, yes.
But then this court is finding it finding is very difficult. Right? In para 2, he said that there are 238 days delay in preparing this present restoration application from the date of withdrawal of the previous one. Is it correct?
You know.
The meaning which you portrayed.
Yes,
And the para 3 which is just read now, that from the date of withdrawal of the application for the restoration, from the date of withdrawal of the application for restoration till the filing of the instant application for restoration, there was a delay of 70 days. So that is where the court is.
It's wrongly calculated.
No, we do not know wrongly calculate or what is.
Simple case of my friend is his writ was dismissed on 1st Feb 2021.
Yes.
And there was a delay. Now, in the meantime, Supreme Court has excluded certain period. Thereafter, he filed a restoration application and he withdrew again.
No, his
now,
writ petition, see, just a minute, his writ petition was dismissed during the period of COVID. Where the exempted period was an operation, when it was enforced.
Right.
So there is no dispute to that.
There is no dispute.
Now, what happened thereafter, after dismissal, he filed an application number 181 2023.
23, and he withdrew.
And then he says there was a delay of 898 days in filing that one, the earlier application.
Earlier application. So his calculation is wrong. The simple case is, my lord, his writ was dismissed during COVID time. COVID time, certain period excluded by Supreme Court. And thereafter, he has to count his limitation period from the 4th January 2022 till filing of the instant application. And in that case,
from 4th January 2022.
Yes.
But then he said period exempted was till 28 2022.
It is wrong. So I have given a short reply. It is stable. So it is a defective application filed by my friend. Earlier also he withdrew because of this ground. Lordship has passed an order, allow him to withdraw because of this COVID period. And now he filed the application again with wrong calculation.
This court has passed the order.
Yes, yes.
This court was not.
My lord,
there.
Page number 28.
During COVID time.
20, page number 28.
Page number 20.
Yes, the lordship order is there.
Mr. Sangma, it has become very tough case for this court.
Page number 28 of the application filed by my friend.
Page
28, 28.
Page 20.
Yeah, 28.
28.
27 and 28.
28.
Yes.
28 is operative part.
Yes.
My lord, Mr. P.D. Sangma, learned counsel appearing for petition submits that the petitioner may be allowed to withdraw this petition with liberty to file a fresh prayer allowed. So this one also, my friend has
This
filed
order
it.
was passed on 12/4/2024.
Yes, yes.
Isn't it?
Yes, yes.
So where is the reference of this here? Oh, achha, this is where we drawn on 12/4.
Withdraw. Now, this application MC 181 of 23 was filed by him, ignoring the COVID period exclusion by the Supreme Court. We pointed out, therefore he said, allow me to withdraw, I'll file a fresh. So Lordship allowed. So now he has filed a second restoration application. And that calculation, nobody knows how he
That was only for the purpose of helping him in that.
Exactly. I pointed
Seek
out
benefit of that execution.
Yes. I brought the Supreme Court order, in fact, for his favor. But now he annexed that one and the calculation is absolutely wrong.
Mr. Sangma, what to do?
Your Lordship, there may be defect in the
Which way you
calculation.
plan to succeed? You prepare a separate thing. You do not know if we allow you to withdraw again and file a fresh. That may spoil your case smooth. Think over, and if you can make a proper calculation in a nice way, you can place it at the time of hearing. Otherwise, very difficult for this court to understand what you have.
No, actually, what I'm trying to state it in this is para 24, the subpara 3. Maybe Lordship is not be able to understand, but according to my calculation, including there was a delay is only for 491 days, Your Lordship. That's why that is my conclusion, Your Lordship. There may be defect in my conclusion. However, Your Lordship.
So, according to you, there is a delay of process. And then, what is the explanation for that delay?
Yes, that
We'll not make it complicated. We'll just go by what you say.
Yes, The explanation for delay.
So according to you, see, the delay which requires to be explained by you is for 491.
Lordship. That is
Beyond that period, you are not required to give any explanation.
no, it required.
Though actually, as per your conclusion, there is a delay of 899 days.
Yes.
Correct?
Yes, Lordship.
Do not end up being confused.
No.
Because whatever you say, this court will note and court will pass this.
Lordship.
So according to you, delay is 818 days, and you will be, because of that
COVID
exempted period,
Yes.
during COVID, you are required to explain delay only for
Yes.
90.
490.
Yes. And what is the explanation you have given for
The
this?
explanation is the explanation because there was some miscommunication between the advocate who was taking the case before earlier, previous advocate and with the petitioner, and then due to some reason there's communication gap, and he was not able to inform the dismissal the disposal order to the petitioner.
Now this period of 491 days
Yes.
runs
Yes.
from which day to which day?
Yes.
From which date to which date?
That is from 28/02/2022 till the filing of the application.
When did you file the application?
This application is filed on 21 June 2024.
So this is the period of 415
Yes.
491 days.
That's it.
Yes. And where is the explanation for this, for that period of 2022 in your petition? Where you have made that?
Yes, I have I have stated in para 8 to para 8 and para 11, para 8 to 11 of my application. The ground. Yes,
Para 8.
Para 8 to till para 11. Para 11.
No, where is the explanation of the
Yes,
period?
Lordship,
and all?
that may I read you the para 8 of this. However, the newly it started from para 7. Para 7.
You just show us the date.
Yes. The reason is that
for which the condonation is sought for. The date. You start from that. 22 means the first March. You start from 1st March. From 1/3/2022, which way you have explained your delay?
that is again I have to come back to the para 24, the sub para 3.
Wherever you have where you have mentioned this dates, just say. Yes.
From the date of withdrawal of the application for restoration till the filing of the instant application for restoration, that is as on 21/06/2004, there was a delay of 70 days. That is to say that application for restoration was withdrawn on 12/4/2024, and the instant fresh application for restoration was filed on 21/06/2024. Therefore, the actual delay was 1,206 days, but excluding the period with effect from 15/03/2022.
We do not know, Mr. Sangma. We are not getting anything. There is no explanation at all. Where is that explanation of that period of 491 days?
Para 25, my lord.
Where is the statement it ran from which date to which date?
The limitation, and hence there is a delay of 491 days from.
There is no problem, 491 days. But then what is the explanation for that period?
Yes, Lordship, that's para 25, man.
You have
the said delay was caused due to unforeseen and unavoidable circumstances beyond the control of the
What are those circumstances?
That
What are those unforeseen and
yes, that
unavoidable?
circumstances I have make a statement in para 7 to para 11 of my till para 7 till para 11 of the application. That are portion.
Where is that?
Yes, may I read it from
Yes.
para 7 till I will read it from para 7 to para 11 mild. That after due deliberation and allowing the impending situation, the applicant had engaged another counsel in the second week of the January 2020 as to ascertain the status of the matter, and inform the same to the applicant, and thereafter pursue the matter before this honorable court. That, however, newly engaged counsel, upon checking the record as well as CICS, was surprised to learn that the matter was already been dismissed for default. White order dated so and so. The same was accordingly informed to the applicant along with the copy of the order dated 20/01/2022. That upon learning the said order, applicant come to Shillong as to meet their counsel on 30/01/2022, and accordingly, after due deliberation, the applicant decided to file an appropriate application before this honorable court for restoration of the said WPC number 103 of 2017. That thereafter, applicant through their counsel had applied for certificate of all the relevant documents, including the petition, affidavit, etc., from the registry of this court as to pursue the matter in right earnest. That after obtaining the copies as per Garu customary law, considering that the dispute involved Nokmasip, the applicant had a meeting among all the Maharis and Chira of the said Akeng clan, and finally, after due deliberation, the resolution was passed on 03/05/2022, where it was decided resolved to pursue the matter before this honorable court. Another ground, paragraph also in 14 also have stated. In pursuance to the said resolution,
You're skipping 12 and 13.
yes, Lordship. No, I'm reading. I'm reading, Lordship. 12, also 13 till 15, Lordship. That in pursuance to the said resolution, the applicant sought legal advice from their counsel, and after deliberation of the applicant decided to file an appropriate petition for restoration of the matter. The port 13. That, however, due to extreme financial constraint coupled with the otherwise poor financial condition of the applicant, they had to avail the help of their family members and relative for financial support, and finally with the help of Mahari, as also relative of the applicant, the money required for minimum expenses were arranged sometime in October 2022. 14. That thereafter, in most unfortunate turn event, the applicant number 1 fell ill due to old age in November 2022, and only recovered after a considerable time and treatment of about 4 months. That is,
any medical certificate enclosed?
Your Lordship,
have you enclosed any medical certificate?
There was no medical certificate, Your Lordship, because what I was instructed is because
number 1.
Yes, yes.
There were more than one applicant.
Yes, there are 2.
The applicant number 2 was not in.
Yes.
Okay.
Yes. Applicant number 1 is the main yes, petitioner, that petition.
Main petitioner, you said this is a clan. Somewhere
Yes,
you
clan.
said this is a clan matter.
Yes, clan.
Then?
Yes. Yes, applicant number 2 is the son, their mother and son.
Yes. So definitely.
Yes.
Fell ill. There is
That
no
Your Lordship,
description.
Lordship, what instruction was, since they were taking the treatment with this since local medicine, that's why there is no certificate. Since there is
There is nothing. You have not elaborated what kind of illness you have. You see, nothing is there. Just a general statement. Then again, you say that the next paragraph. See paragraph 15.
Thereafter,
we'll come back after lunch break. Just come back.
much. Yes, Lordship. Lordship, actually, I'm trying to explain the delay of 421 days by reading those para which I have explained earlier. It is from para, it start from para 7 and 10, 15, 18, 19. I have read out to the Lordship till para 14, Lordship. Then para 14 where I mentioned that due to sickness and due to old age, the applicant was not able to prepare the application within the prescribed period of time, and there was some delay in filing the application for restoration. That was I'm trying to submit, Your Lordship. However, Lordship has asked there isn't any medical certificate, but then to that effect, I humbly submit, Your Lordship, since what I was instructed from the applicant, since the treatment was not taken from the hospital, since he has been taking the treatment from the local medicine, which they don't have any certificate, Lordship. That's that was my submission, Lordship.
It's very difficult to understand what you have written in your, what you have stated in your application. Very confusing. Paragraph 20, 21, 22. Yes, Mr. Samresh.
My lord, this the cost title, Lordship, you can see he sought for condonation of 518 days in the cost title. It's contrary to my learned friend's submission.
No, I think it's no, not 500. It is 800.
Which part? Post title at page?
Maybe there's a mistake.
The application under Section 5, Limitation Act for condonation of 518 days.
There is no application under Section 5 here. This is application under Chapter 3, Rule 4.2.
This
of the
copy,
Meghalaya High Court rules.
the copy that he supplied to me, we received this one.
There's a mistake, but what Lordship is saying that is correct. But my Lord, because that application is telling the earlier withdrawal one he is referring. After that,
Now,
I have
which copy is you have given?
now he
This
is
case number 108.
Which copy have
this is the press application, and the date of filing also is different. I think. It's referring to different date. It's,
24.
June 19.
We are dealing with miscase number. Right now, we are dealing with what? Miscase number which one?
We are miscase. We are dealing with miscase 108. He has filed also affidavit regarding 108 on the Lordship. It's correct. But there is some mistake in his.
But he has served me a wrong copy. Perhaps he has corrected copy he has filed. A wrong copy has given to me.
Even in his affidavit,
I filed my show cause also. This is my lord. I'll just explain. Lordship, kindly come to my my show cause. Para 15.
No, what to do about then? Where you say 521 days and then
the copy he has given to me. This copy he has given to me. So he clearly mentioned that an application under Section 5 of the Limitation Act for condonation of delay of 518 days as on 19/6/2024 is in preferring the instant application for restoration of WPC number 103 of 2017 against the dismissal order 0102-2021 for default of.
So what is to be done now?
Therefore, apart from this also, I have explained the delay is a 700, 751 days delay after exclusion of the Supreme Court exemption. I have explained in my show course, para 15. And secondly, my lord, the ground taken by my friend that the due to financial difficulties is a NOCMA, is not individual case. So the explanation given by him that due to financial crunch, he could not file. They cannot file application is absolutely not correct, not acceptable. Number two, that he was not keeping well. Two applicants are there. It's a NOCMA matter. And Lordship has pointed out the no medical documents also annexed here. And other applicants is there. Other applicants could have filed the application also. In fact, therefore, there is no such application at all. Such explanation is not there.
What is your shokos? What is your objection?
My shokos I filed on 16/9.
Yes, and which
2024.
paragraph you have taken?
Page
lord.
9 he has. Para
Yes, yes. Let him address. Sit down.
Lordship. Para 15, my lord, welcome to explain the delay part, the time part.
Here?
Para 15, page number 8. Para 15, page number 8. Madam, that in reply to the argument made in paragraph 22, 23, 24 of the answering, deponent denied the same in toto and begged to state that the delay in filing the instant application by the petitioner issue applicant is of 1233 days. However, the Supreme Court has excluded the period with effect from 15/3 to 22.
Now, how you have concluded that 1233? What is the basis of calculation?
My lord, I'll come to that the Supreme Court order.
No, that total period of 1233.
Yes, that is from the data passing the dismissal order. The exclusion will come, my lord. For the purpose of computation of the limitation, which comes to 715 days. It is pertinent to mention that 715 days will not be excluded in computing the delay in the petitioner case, as the petitioner case was dismissed on 012/2021. As such, the time for computation of delay shall be counted from the 1/0/2021 to 8/28/2022, which comes to 392 days for the purpose of computation of the limitation in the petitioner case. As such, there is 841 days delay in filing the instant application by the petitioner. However, the Supreme Court
Delay of
has
exempted period has to be counted only from the date of dismissal.
Yes.
Cannot go before.
Yes,
Isn't it?
right. However, the Supreme Court has extended the limitation period by 90 days from 01/03/2022, taking into consideration the extended period of limitation of by 90 days. The actual period of delay in filing the instant application by the petitioner is 751 days. Hence, the condonation application filed by the petitioner is defective and liable to be rejected. So this is, according to us, 751 days.
No, that is, you say correctly that how can the period, entire period of delay be counted, especially the period which were there before the dismissal of that.
Right.
This Supreme Court period starts from 2020, isn't it?
Yes.
And his writ petition was dismissed 2021.
21.
So entire period cannot be exempted.
It cannot be exempted. Cannot be exempted. So he got the grace mark 90 days, and that would effect from 013.
He got a,
Now may I show the Supreme Court order? My friend has annexed Supreme Court order.
just a minute, just let us just clear the confusion. Now, total period exempted by Supreme Court is 715 days. From 15/3/2020.
Yes.
Now from 15/3/2020 till 1/2/2021, how many days it is?
My lord, from till my lord. Till
From, say, supposing from 15/3/2020
yes.
till the date of the dismissal of the writ petition. That is on 1/2/2021.
Yes.
It comes to how many days?
My lord, from the day of Supreme Court order, lordship is referring.
So 392 days. Just a minute. So according
Yes.
to you, he is entitled to exemption of 392 days only, and not 715 days. Yes.
No. He would be, my lord.
See, kindly just
Yes.
do not know whether court is able to communicate to you. The entire period exempted by the Supreme Court because of the COVID starting from 15/3/2020 till 8/28/2022 comes to 715 days. Isn't it?
Yes.
Now you say that since the writ petition has been dismissed on 1/2/2021, the period prior to it will not be counted.
It will not be counted.
So it will be then in such a case he will only get the benefit of 392 days, isn't it?
Yes.
So that is what.
Yes.
So that 715 days will not be counted.
Not counted. There's a prior to dismissal of the case.
Okay, just a minute.
Therefore, the actual day of filing this application would be 751 days. Delay for filing the instant
How can it be?
application. Well, that one, my lord, may I just show to the Supreme Court order. My lord, we come to page number 33. Supreme Court order is there.
Just a minute, Mr. Sangresh, we'll just come to what you say. Since this petition has been made in such a way, court finds it very confusing. Now, so far as the facts, admitted facts are concerned, the writ petition comes to be dismissed on
First,
1/2/2021, isn't it?
Yes.
Now, he filed this restoration application, this condemnation application on 24. This present application.
The present application. My lord,
Present
here he
application
has
was filed on
mentioned
29 June.
19 June 2024, according to my copy.
It is filed on 13th August 2024.
13 August, my lord. In my case, 19 June 2024.
No, not 13 August. Sorry. Wait. This court is looking at wrong application. It is 21st June.
Yes.
It's filed on 21st June 2024.
Yes.
That means after a period of how many days?
That would be, my lord, after a delay of 700.
Just say that. Do not say about the delay. Just after a period of total period of how many days?
Well, the total period without excluding the Supreme Court.
Just
period.
even without, do not even count the 30 days also, the normal time which is available. What is the total period? After how many days it was filed?
Well, that would be, according to our counting, my lord, 1,233 days.
Just a minute. You have to do a lot of arithmetic now. After 1,233 days.
Well.
Now, out of that, normal period is 30 days, statutory period. Plus that 397 days, as you admit that he is entitled for 392 days. So you have no dispute with regard to that calculation of 1, 2, 3 days?
He has a dispute in his application.
Wait. Then it comes to 811 days. See, if you say, if there is no dispute that the petition was filed after 1233 days, then if you deduct the 30 days, the normal period which a party is entitled to, if you deduct that, then it comes to 1203 days. Then if you deduct further 392 days, as per order of the Apex Court, then it leaves behind 811 days. Now that this period of 811 days requires explanation.
There is no explanation.
So this calculation here, whatever you have made, is totally wrong then.
Paragraph 15, my lord. Paragraph 15, lordship is referring to.
No, so far as you are concerned.
Yes.
So far as the petitioner is concerned, and then your calculation is also not correct then.
It seems in that case, my lord,
You say 751 days.
lesser than the lordship's calculation in that case.
Okay, there is a further extension of 90 days.
90 days. That is. So whatever, my lord, may be 500 days or 600
so that
days.
means the period of exemption is not till 28 to 2022. It is up to 1/3/2022.
Yes. 1/3/2022.
So another 90 days from 1/3.
According to my calculation, it will be exclusion would be till 3rd January 2022, and the delay started from 4th January 2022. So he has to explain from 4th January 2022 till filing of the case in 2024. And in short, there is no such explanation. Even if my friend entitled lesser days, still then there is no explanation.
No, just a minute. You are not disputing that fact in your paragraph that the Supreme Court has excluded the period with effect from 15/3/2020 to 28/2/2022.
Yes. Right.
Isn't it?
Yes. So even my calculation
that will be
750 days.
that will be basically inclusive of the 30 days, the normal period.
30
right?
days. 30 days.
Now, from 2022 till the filing of the case, how many days?
According to our calculation, 751 days. And according to my friend, it is 400 something only.
How can it be?
That is why. So assuming that 400 days or 700 days, there is no explanation.
But then what is this what you say about this thing, if the extended limitation period 90 days from 1/3/2022?
Yes. My lord, that is because of the order in Supreme Court, page number 33.
Of his
Of this application.
You have to make a tabulation, mister. Very difficult.
We can make a tabulation
Until
within 40
unless
days.
correct calculation is made, which we will your prayer is for 449 days.
Yes.
491 days.
Yes, 401 days.
So more than 1 year's years are not there. Page number 33.
That's become very complicated.
So if Lordship give us 2-3 days, we'll make a tabulation on the table.
Mr. Sanganeshu, that would be better, but then the thing is that, you see, kindly give us the period which you are not disputing, which is not at all disputing. Except that part which you say 771, that is, of course, that we have to calculate, and then we have to see whether there is a proper calculation or not. But then, if this position stands admitted that the exemption was till 28/2/2022,
22.
then according to you, there is a further extension of that.
My lord, no, my lord, there is
So
no further
according to you, this period of exemption would be till which date?
extension will be including 90 days. It would be, my lord, 3rd January 2022.
How can it be?
That one, if lordship kindly
22
see page,
No, if you include these 90 days,
my lord, may kindly see page number 33, Supreme Court order,
page 33.
33.
Yes.
The Supreme Court order.
Yes.
Therefore, with dispose of the MA number
Page
665,
33, which you are reading which?
my lord, para 8
Yes.
on the top, matter. We dispose of the MA Such 21 with the following directions.
Yes.
In computing the period of limitation for any suit, appeal, application, or proceeding, the period from 15 March 2020 till 2nd October 2021 shall stand excluded. Now his writ petition was dismissed on, my lord, on 1st February.
It was further extended, isn't it?
Yes, now extended. Consequently, the balance period of limitation remaining as on 15/3/2021, if any, shall become available with effect from 03/10/2021. Now, in cases where the limitation period would have expired during the period between 15 March 2020 till 2nd October 2021, writ petition was dismissed in between this. Notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 3rd October 2021. In the event the actual balance period of limitation remaining with effect from 3rd October 2021 is greater than 90 days, that longer period shall apply. Now, according to me, my lord, the writ petition was dismissed on 1st February 2021. And he would entitle the
Just a minute. Dismissed on?
Dismissed on 1st February 2021.
Okay.
And Supreme Court exclusion of time, he would entitle, my lord, till 3rd February 2022, including 90 days.
But that statutory period of 30 days was extended to 90 days.
90 days.
Normally,
it's
for the
only 30
limitation
days.
act, registration has to be in 30 days.
30 days only.
But then it was
90 days. Supreme Court has given a grace period. So, enjoying that 90 days exclusion, he will enjoy till, my lord, 3rd January 2022. Till 3rd January 2022, he enjoyed that exclusion, exemption of that. And the clock of limitation period for my friend will start from 4th January 2022.
yes.
4th January
Till
2022.
the filing of the
Yes, till the filing of the instant, August 2024.
till 21st June.
Yes, 21st June. So it is more than 700 days, 750 days. There is no explanation.
$751.
51 according to our calculation. There is no explanation. That is my case.
And his explanation covers which period then?
But no period is covered. It's difficult to identify which period he is
He's
covering.
491 days operates from which date to which date?
We don't know. This is the problem.
What about this 751 days, Mr. Sangma?
That 751 days is actually that I have considered as excluding date there, where I have mentioned in my para 24, according to my understanding and calculation. I have elaborately explained in para 24.
Please say clearly. This court is not getting it.
According to my calculation, everything which I have explained in calculation, everything and minus, everything
According to you,
that is yes,
just-
according to
just
me.
a minute, just a minute. Just let us simplify. According to you, your period of limitation will run from which date? Give us the specific date. From which date your limitation period will run?
It will run from the 28 February 2022.
Yes, 28 February 2000. Not 28, then 29 means 1st March.
Yes.
Up till 22, this thing is exempted.
Yes.
Now from 1st March 2022, yes, we do not know. This court also will get confused. So many calculations. This 28 to 2022, you are saying on what basis?
That is a period of exclusion.
Where it is mentioned?
In the para 24 subpara 3 of my
No. Where is the Supreme Court order? Where is it? Where it is there in the Supreme Court order? So it means the extension is not Mr. Shangresho.
Yes.
The apex court's exempted period was not till 2028 to 2022.
Yes, no.
It was wrong.
Wrong. That is wrong calculation. Wrong calculation.
After 3rd January, in fact, there was no period.
Yes.
After 3rd January 2022.
Yes. Limitation.
Not only for his case, for all matters. Isn't it?
Yes.
Yes. Your period from which date to which date? First,
studied-
you show where is the order of the apex court on the basis of which you claim benefit till 28 to 2022.
That's page 33. my lord.
Yes.
According to my calculation, that page 23, para 8, subpara 3,
Yes.
which I have stated that my calculation started from 0. 20 yes. 15 March 2020 till 0 to 10 2021. So starting according to my calculation, it started from 0 to 10 2021.
You have not understood. Please say it again.
According to my understanding, Your Lordship, I have counted the date of excluding, minusing what.
Where it is said, see, your counting cannot be of your own, isn't it? It has to be on the basis of the apex court order. Since you are since you are basically seeking benefit of that, isn't it?
Yes.
So please tell us which part of the apex court order shows that you are exempted till 22 2022.
Page 33, my lord.
That is all right. You show us where. We have come. We are already in page 33. Para 8, subpara Roman
3.
Yes.
So it started from 15 March 2020 till 0 to 10 2021. So I have started the calculation exempting started my counting day from February from 0 to 10 2021, minusing.
So on what basis you are seeking exemption from 0 to 10? Where it is provided that you are exempted for that period also.
Lordship, it is may I read my application then para page 7 para 20.
Your application is very confusing. Your application is so confusing.
That para 20 I have stated, madam.
Yes.
That the Honorable Court in sum of the extension of limitation period, limitation reported in 2022 SCC 117 was pleased to exclude the period with effect from 15 March 15/03/2020 to 28/02/2022.
Where from that 28 to 2022 comes? Just tell us. On what basis you have said? Or you show that SCC 117 2022?
This one is there. 10, 10, 10, 8, 20, 28.
Mr. Sangreshu, can you just prepare a
Prepare a
chart and give it?
yes,
We'll
yes.
have it on Monday then.
Yes, yes. Only one
The
page.
things will become simpler.
Yes, yes.
Just make it specific.
Yes, yes.
Now, so far as your contention is concerned, this court is understood.
Yes.
But then what basis Mr. Sangma has come to that calculation 491 days?
Very well.
Till now, this court is not understood. And even if we accept that 492, but then runs from which date to which date we don't know.
Yes, we don't know.
And that on what basis he is claiming benefit up to 2022, that is also not understood.
Right. So I'll prepare one page tabulation and submit on Monday.
So we will not pass any order, we will just simply adjourn it
Yes.
to Monday.
Yes.
Monday will go. When can we leave it? We can do it. Let's see which date. After 2 weeks. 2 weeks. 2 weeks will be too long. This is order matter.
Or might not be reserved the judgment, we will submit within 2 or 3 days.
No, once you give a calculation, you will also get a chance to go through it. We have it on Monday in the order column, if there is no much matter. Or Tuesday, or Wednesday, just see order columns. It is part 1 matter.
Anything next week. Anything in the next week, convey the subject to lodge complaint.
Thursday, we'll have it on Thursday. Hard landed counsel for the parties at some length. Stop as prayed for. This is matter on. Give it the date. Thursday for further hearing. Please, this is so much confusing, and it is.
Item number 2.
Yes. Dr. Mojika. Yes.
This is the matter, my lord, where the Union of India has come by way of a 482 application before the Lordship, my lord. But here, what happened, my lord, in last year Cherry Blossom Festival in Umiam, my lord, there was an army enclosure where meant for army officers only. And there was some scuffle between the army officers and Assam Rifles officers, my lord. So some kind of fight. And
Army and Assam Rifles.
Army and Assam Rifles officers. After that, my lord, the Assam Rifle, the Army authorities informed Assam Rifle officers informed the Army, my lord, and pursuant to that, Army has taken action and instituted a court of inquiry, my lord, under the Army Act as a fact finding what actually happened on that day. Thereafter, the Assam Rifles officer who was hit, some injury was caused to him, he filed an FIR before the police station, my lord, Lawan police station. That was as a 0 FIR, and that was transferred to Umiam police station, my lord. Now here, 11 army officers are named in the FIR, my lord, starting from GOC and lower ranks also. Now what has happened, my lord? The court of inquiry is going on somewhere in West Bengal, my lord, and all the 11 accused persons are there attending the court of inquiry, and many witnesses, so many witnesses are also there, and court of inquiry is going on, my lord. My lord, lots are aware that under the Army Act and CRPC, there are provisions that if the offences are related to army officers, my lord, the army can claim the case after filing of charge sheet from the criminal court, my lord. I'll take your lordship to the provisions.
That is not required. That is probably will not be disputed. You can claim trial, nothing. We cannot claim investigation.
We cannot claim investigation, my lord. As on today, what is happening, my lord? The court of inquiry is also sort of investigation under the Army Act, my lord. And police are also conducting, and there is, in my humble submission, there is no bar, my lord. The police can investigate the FIR, Army can also investigate their court of inquiry. There cannot be any other submission on that, my lord. But the only difficulty what we are facing, my lord, that police is also investigating the matter right now, and all the witnesses and all the accused persons are somewhere in West Bengal attending the court of inquiry, my lord. So, my lord, at this juncture, my lord, in fact, the matter can be even be disposed of, my lord, only by giving some kind of postponing the police investigation till for about 3 months' time, my lord.
Unless you show us some law, because law is against you. Basically,
my lord,
just because you have instituted an inquiry,
my lord,
cannot be a ground for scuttling investigation by police. Your right basically starts from the stage of charge sheet, as you have already said.
My lord.
You can claim trial, but then cannot ask for quashing of the. Your prayer is for quashing.
But I'm diluting my prayer, my lord. I'm not asking for quashing, my lord. I'm only asking.
But then how can see if we have to withhold the investigation, that comes to same thing. It amounts to stay
only for a limited duration, my lord. Maybe for a period of 10 weeks, my lord.
You show us some law.
We complete
some authority. Otherwise, we will not. We do not think that 482 should be exercised for giving this kind of benefit. And more so when the applicant here is innocent. Whatever you say, it may cause inconvenience to those 11 officers. But which way you are?
Not only 11 officers, my lord, because the court of inquiry is held by the army authorities, my lord, under the Army Act. It's not any individual officer who is affected by anything. Why Union of India is for lordship, my lord? That all 11 accused persons are there, my lord, attending the court of inquiry. So many witnesses. I do not have the exact number, but must be 30, 40, 50 witnesses. They are also camping there, my lord.
So that will be adjusted. But then this cannot be done. This how can it? Until unless you show us some law.
Well, by invoking energy only for a purpose that 10 weeks, the police will postpone the investigation, and once we complete the court of inquiry.
By this court already in this matter.
My lord.
Mr. Khera has placed another.
My lord.
Asking the investigating authority to complete. So we will not dilute that direction until and unless you can show us some law.
But only for the purpose of for the ends of justice, my lord. 482 can be invoked for that. For
ends of justice will be achieved even if this investigation is proceeded very fast.
Well, ultimately, your lordship will see police does not have the power to prosecute, my lord.
That
because
the
army has
that will be still when that stage comes.
Because army has the power to claim the case, my lord.
Do you want to say? You see, has the power to claim,
my lord.
But then it is not that army will always claim. If they do not claim, can't they proceed in a court, normal court?
Because here, what has happened, my lord? Lordship, one vital factor which is there, that on the request of Assam Rifles, my lord, we started a court of inquiry.
That is okay. These are all factual aspects. May not be gone into by this court at this stage.
And kindly give us at least 8 weeks time or so, because the FIR is otherwise also
No,
FIR is very
we'll
belated
not,
FIR.
we'll not, because we have already passed an order.
Well,
There
that
is
that
some other round of
well,
litigation,
that order was passed in our absence.
wherein a specific direction was passed, directing the investigating authority to complete the
Well,
investigation.
that order was
Yes.
passed without we are not a party in that order.
That is okay. That is okay.
And
That is okay.
And,
So
and they are here,
you
my
can
lord.
definitely, if you show us some law, that yes, some order can be passed, then only you see. Otherwise, we will not like to write.
Only to that extent, my lord, the investigation is stayed only for 8 weeks.
Yeah.
Let them complete the court of inquiry and they
You must show us some law where we can do it.
But law is only for it. I'm only submitting before lordship that parallel investigation at the same time, my lord. And there are so many accused person and so
If
many
law does not bar it.
so many witnesses.
Law does not bar it.
Right.
Why should we?
The law is doesn't
makers
bar,
of
but law is not saying also, my lord, that it can continue parallel.
Yeah, but then it doesn't bar.
It doesn't bar
investigation.
also.
It doesn't bar investigation. Otherwise, there would have been clear-cut bar, barring the general police to investigate the matter involving. You will find there are instances when a criminal act takes place within army area. There also the army authority files FIR with the police asking them to investigate. There are instances, several instances.
Yes. To that extent, we will also kindly because they are here, my lord.
At this stage, we are not.
My lord, why I'm submitting, my lord? Even the state should not be agreed with such prayer, my lord. Even the complainant should not be agreed with such prayer. There is no reason for them to agree because we are acting. Army authorities acting on the complainant's complaint, my lord.
Dr.
We are holding court of inquiry on the same
has
thing.
rightly or wrongly has passed some order.
No.
And this court basically would not like to interfere with its own until and unless there is a legal compulsion to do it.
But that order is like, my lord, though that sentence has
We will not contradict
is there,
ourselves. In one order we say we proceed early, and the other order we say you just withhold the investigation for 7 years. We will never do that. This will be a mockery of justice.
But they are here, my lord. If they are not agreed with that, my lord can.
This is an order passed already.
That's not a prayer, my lord.
Yes. Lordship, our initial objection was on the locus, Lordship. But now that this submission has come from the learned senior Lordship, as your Lordship has rightly pointed out, one order has already been passed by this honorable court for expeditious investigation, Lordship. And Lordship, I've just heard something from my friend. If my friend can kindly submit.
So your submission is you are not pressing on the question of locus standi, right?
Locus standi, because they said they are not pressing on that, Lordship. They are pressing for stay. We are objecting to that, my lord.
They are pressing for passing of some kind of order.
Lordship, we are objecting to that, my lord, because the police has full, I would say, power to investigate into the matter.
Other case.
Yes, Mr. Khera.
Hello. My lord, as on date,
You are appearing for response number?
the complainant, my lord, responding number 3.
My lord, we have absolute objection to the submission that the inquiry should be stopped and stalled. In fact, my lord, the genesis of this case goes that the medico-legal sheet, the medical examination which was done was forwarded to Kenchester's police station. Now, my lord, reasons best known to the police station, nothing was done. I was waiting with bloodstained clothes and a lot of evidence was there, my lord. Nothing happened. At last, my lord, around December, mid-December, 14th of December, I was called from Kenchester's police station. I made some inquiries as to what is happening. The army authorities,
See, we are not much concerned about the factual aspects.
My lord. My lord, if we come to the law, the locus standi was challenged, my lord. Now, my lord, this particular petition has been signed and filed by a gentleman who's
Just address us on the point
my lord,
whether Union of India
my lord.
can claim any sort of what to say, like can they come with any sort of prayer at this stage?
They cannot, my lord, because it's a criminal proceeding, my lord. I put a simple question to myself that the gentleman, the officer signing this particular application, the petition which they have filed, if the 11 accused person they are convicted, will he go and get incarcerated in his place?
Of course, we are.
My lord,
we
why?
may not
Because
go that. See,
and
one thing is that just confined to the
my
legal
lord,
now, so far as we understand, maybe the petitioner herein
my lord,
will have a right to claim trial, but then that right would accrue only after matter is charge sheeted,
my lord,
isn't it? Now, before that,
my lord,
whether they have any right.
they don't have the right, my lord. The law is settled in a catena of judgments. If I may place a few, my lord, in state of Sikkim versus Jasbir, in Chandramohan, my lord, in Sanjay, in GOC versus CBI.
What do you say there?
My lord, all the judgments collectively say that both the investigations can go on at the same time. But then they also come to say that my lord, the whole genesis behind 125 is that once the charge sheet is filed, that is the time that they have the power or they have the privilege.
Exactly, that is what the understanding of the court
My
also.
lord. So to charge sheet for to be filed, my lord, investigation has to take place. Now I don't know what is their fear, my lord. Is it that the accused are trying to say we will choose the forum where investigation will take place?
Dr. Mojika, show us the provisions under which you can claim trial.
My lord, 125 is the only provision under the Army Act where they can claim trial, and that is also not an absolute right, my lord.
It's all right, it's all right. We are not in that stage. We may not have to go further. We just want to know what it is.
Prior to that, on the maintainability aspect, my lord, if permitted, I have a very small submission to make. May I, my lord?
Yes, yes, please.
My lord, page 7, para 12. My lord, in this case, a third party who had got nothing to do with the case comes and files an application under 482. Here, my lord, from quashing now they have they say now their prayer is to stall the investigation. My lord, the similar question here was, but it was to expedite the investigation. My lord, para 12, if I may.
Yes.
7.
Yes.
With regard to locus of a third party to challenge the criminal proceedings or to seek relief in respect of criminal proceedings of accused had been dealt with by this court in Janata Dal versus H.S. Chaudhary and others 1993, 1 SCC 756. In the above case, the CBI had registered FIR under the IPC as well as under the Prevention of Corruption Act 1947 against 14 accused. On an application filed by the CBI, the learned trial judge allowing the application to the extent that the request to conduct necessary investigation and to collect necessary evidence, which can be collected in Switzerland, passed order dated 5/2/1990, which was to the following effect. In the result, the application of the CBI is allowed to the extent that a request to conduct the necessary investigation and to collect necessary evidence, which can be collected in Switzerland, and to the extent directed in this order, shall be made to the competent judicial authorities of the Confederation of Switzerland through filing of the requisite proper undertaking required by the Swiss law and assurance of reciprocity. A criminal miscellaneous application was filed by Shri H.S. Chaudhary seeking various prayers before the special judge, which petition was dismissed by the special judge. A criminal revision under 397/482 CRPC was filed by H.S. Chaudhary in the High Court to quash the order of the special judge, which revision was also dismissed by the High Court. The appeals were filed in this court by different parties challenging the said order, including H.S. Chaudhary. This court, while dismissing the appeal filed by the H.S. Chaudhary and others, made the following observations. Even if there are million questions of law to be deeply gone into and examined in a criminal case of this nature, registered against specified accused persons, it is from them and them alone to raise all such questions and challenge the proceedings initiated against them at the appropriate time before the appropriate forum, and not for third parties under the grab of public interest litigants. We, in the above background of the case, after bestowing our anxious and painstaking consideration and careful thought to all aspects of the case and deeply examining the rival contentions of the parties, both collectively and individually, give our conclusions as follows. Mr. H.S. Chaudhary has no locus standi A to file the petition under Article 51A of a public interest litigant, praying that no letter rogatory request be issued at the request of the CBI.
26 is good enough. I think, don't think that
My
is
lord.
the repetition of the same proposition.
My lord, same proposition. My lord, para 14, the court wraps up. This court in the above case laid down that it is for the parties in the criminal case to realize all the questions and challenge the proceedings initiated against them at appropriate time before appropriate forum, and not for the third parties under the grab of public interest litigant. My lord.
Now, it is not a public interest litigation.
My lord, but the question is of a third party over here, who has got no standing, no relation to this case. My lord, in Chandramohan matter, my lord, page 29, para 70. My lord, page 29, para 70. May, my lord?
Just.
Page 29, para 70. Last paragraph on the page.
Yes.
What crystallizes from the above discussion is that even when an investigation by police into an offence alleged to have been committed by a person subject to the Army Act is in progress, there is no impediment on the part of the competent military authority to either investigate the case in terms of Chapter 5 of the Army Rules or in holding court-martial, if any, the accused is not in the custody of the criminal court. Then it talks about custody. What it says is, my lord, even if the police investigation is on, a court of inquiry can be initiated, and it is
okay. We are not on that question. We are not on this question.
My lord, loci is there. There is no.
Is that the question involved here is that, in view of initiation of inquiry by the Army authority,
my lord,
whether investigation by the police should continue. That is the only question to be.
My lord, that they are clear over here. That even if the police inquiry is on, a court of inquiry can go on, and vice versa. My lord, to sum it up, my lord, page 52, para 62, my lord.
These cases are not reported anywhere.
My lord, they are landmark cases. In fact,
That's okay. If you give us the citation, it becomes easy for us.
My lord, I'll give the citation also. We have taken it out from. We tried to get the neutral citations, but it is from the website of the Supreme Court, my lord. It's a report. This is a very landmark case, my lord. In fact,
it must be reported somewhere, isn't it?
My lord, it is. I'll get the citation. My lord, page 52, para 62. It clearly speaks as to the stage, my lord, when they can take up, which means that the whole genesis behind 125 of the Army Act is that police can and once it investigates and files a charge sheet, that is when they come into play. The authorities, prior to that, they don't come. And my lord, it is very interesting that the authority, as they are saying, has to be the authority who's commanding the accused. In this case, my lord, every accused will have a different authority who are commanding them. My lord, para 62.
Yes.
Thus, the law on the issue is clear that under section 125 of the Army Act, the stage of making option to try an accused by a court-martial and not by the criminal court is after filing of the charge sheet and before taking cognizance of framing the charges.
There is no dispute.
My lord,
Dr. Mojika doesn't dispute that.
My lord, last aspect I'll show, my lord, where it is clearly written police investigation can go.
Yes. Give us that one instead of giving so many decisions. Just give us.
My lord. This is the latest on the issue, page 81, para 170. My lord, in fact, we can start from para 163 at page 79.
There are 163.
My lord, page 79. May I, my lord?
Allow the court to make a note, otherwise court will forget.
My lord.
Please. Page?
Page 79, para 163. May I, my lord?
Page 79.
79, para 163. The law is therefore very clear that if an offence is committed even by army personnel, there is no concept of absolute immunity from trial by the criminal court constituted under CRPC. To contend that this would have a deleterious and demoralizing impact on the security forces is certainly one way of looking at it. But from the point of view of a citizen living under the shadow of a gun that can be wielded with impunity, outright acceptance of the proposition advanced is equally unsettling and demoralizing, particularly in a constitutional democracy like us. The result of the interplay between Section 4 and Section 5 of the CRPC and Sections 125 and 126 of the Army Act makes it quite clear that the decision to try a person who has committed an offence punishable under the Army Act and who is subject to the provisions of the Army Act does not always or necessarily lie only with the Army. The criminal court under CRPC could also try the alleged offender in certain circumstances in accordance with the procedure laid down by the CRPC. My lord, para 170, page 81.
Yes.
My lord. However, we make it clear that even if the armed forces decide to take action,
Paragraph
170, my lord, 170. However, we make it clear that even if the armed forces decide to take action and inquire into the allegations at their own level, the court of inquiry,
that is more relevant.
it would not preclude any other inquiry or investigation into the allegations made. Well, this sums up the matter here. The investigation should go on. They may continue with the court of inquiry. And when the stage of 125 comes, when we see that sunrise, we'll decide what is to be done then. But as on date, my lord, this inquiry has to go on, my lord, and they do not have the loci to file this application.
But I've not submitted any time, my lord, that we want to stop or stop. I'm only praying that parallel, my lord, at the same time, because if the IO also calls the same accused person, my lord, and the court of inquiry also examining, my lord, that will cause, lordship, only that much, my
It will
lord.
cause difficulty to those persons, not to you.
My lord,
Even if it is.
my lord, army is an institution, my lord, of the Union of India, my lord. The institution, the army institution itself will face difficulty, my lord, because
Why institutional? These are 11 officers.
My lord, the court of inquiry is conducted in official capacity by army officers, not by accused persons.
But then that is okay. But this is, I don't think that there is any basis in that. That is the same person is called by the investigating authority here and the NPA
that is in a different
authority
state,
there. That will cause difficulty. Difficulty to the NPA authority.
Yes, my lord.
Then should have been a basis for staying the entire thing. Cannot be.
Well,
Law doesn't recognize that.
My lord, only some observation, my lord, that if the IO can take into account that, not to force, only to take into account that parallelly and see the convenience of all the party and conduct the investigation. Something, my lord, should kindly give me something.
See, Dr. Mojiga, until and unless something has sanction of law, why should you pass some direction?
My lord, I'm not saying it is well settled, my lord. Both the authorities have the power to investigate. It is not my case, my lord, that police cannot investigate.
See,
close it or
you
close
yourself
the
is the
FIR,
authority.
my lord.
So you can do one thing, you can coordinate with the investigating authority here. Make your own connection, establish your own connection, coordinate with them.
With IU, my lord.
Whoever it is, the investigating authority, it is up to you. That liberty will always be there with you.
Well, some observation only with that much, my lord, and the matter can be disposed of. Some observation, my lord.
No matter in any case, we will dispose of until unless you satisfy us on the maintainability of this. So, court will definitely pass some order.
I know it is a difficult case for me, my lord, but only that much your lordship can give us. My lord, what is more important, my lord, what I have been told, because there are many things which are not offences under the IPC, my lord, but those are the offences under the Army Act, my lord, insubordination, or these are not offences under the IPC, my lord. So when a court of inquiry conducts an inquiry, they take cognizance of those offences also, which are in IPC or other penal laws. They are not offences, but these are offences under the Army Act, my lord. Because Army Act has many more things which are otherwise are not on offences for me under the IPC or under any other law.
See, if this matter culminates into filing of charge sheet, and even a trial is sought to be, taken up against, in such a case, we will have the right to do that, whatever it is. Your right would definitely start. Otherwise,
No, that right we always have, my lord.
Anyway,
but there should be no bar to the investigation, Lordship. And this has been held by the Constitution bench in the year 1969, Lordship. Until date, it's
you see, so long though Mr. Kera has.
No, that is settled position. No one is disputing.
So that is why. So you need not, because until unless that point is disputed, we need not go into all these things.
No one is disputing that police has the power. Police has the power to file charge sheet, and we have the power to or privilege to claim, subject to approval by the magisterial court, my lord, whether to hand over the case to army authorities or not. My lord, till we are not disputing any of those provisions, my lord. I'm only praying for lordship, my lord, so administrative difficulty, my lord, that which it is causing, just to sort that out.
See, administrative difficulty between two authorities can be sorted out. What is the problem? You do not need any judicial order for that.
Are you state facing any administrative issue?
Well, some observation, my lord. At least I'll go with something.
State here, they are not facing any administrative issue.
My lord, the plea taken up by learned senior with regard to difficulty, this has been filed by the union, my lord, not by the 11 persons who have.
No, it's not about 11 persons.
Exactly.
It's not by 11 persons. We are not. I am not here appearing here, my lord.
See, exactly, madam. That is what. See, like this petition is aimed at more. It is aimed more at protecting interest of those 11 persons. That is what it seems like.
My lord, for sure, my lord, I am not vouching or not appearing for those 11 persons, my lord. My lord, those 11 persons
are prayer you are making.
My lord, those 11 persons are this court. Those 11 persons are facing court martial, my lord, and if found guilty, my lord, they'll be.
We can understand why you are going to that aspect. To convince the court, you do not have to go. But then at this stage, it appears that. You see, like you are more bothered about the harassment which would be caused to those 11 persons.
Not to those 11, not to those 11, my lord. My lord, kindly, I'll submit, my lord. There are witnesses who are army people, my lord. There are 30, 40, 50 witnesses who are camping in one place, my lord.
Yes.
And that the court of inquiry is conducted, the board of officers conducted the court of inquiry, my lord, of the level of brigadier and above, my lord. So, my lord, this is where I'm not appearing or vouching for those 11 officers. They are facing court of inquiry.
They are not directly doing it. But
I'm not even doing indirectly also.
There's an implication of that.
It is not, my lord. It is not.
Exactly. That is what the petition specifically.
This petition cannot breathe.
To seek any kind of punishment. You are not directly involved in the investigation. This investigation.
My lord, our only case is that army as an institution is conducting the court of inquiry under the Army Act, my lord.
There is no bar.
There is no bar. We are doing it, my lord. But when we are supposed to take this statement of witnesses under court of inquiry, same time police is asking for his custody or him to appear before the.
If the system allows it, then that will be done. And just if this inconvenience cause, it will be caused for one day. On the next day, you will have your. It will not be that you see like just because the investigation.
At least the matter can be disposed of. But some observation that IO will cooperate and they'll work out the administrative difficulty.
Directions have already been passed in the previous matter, my lord.
Well, I'm not asking for staying the investigation. The same submission is made.
My lord, it may continue the way it is continuing.
I'm
There
not
is no
asking for
specific issue to it.
investigation, my lord.
So let will pass.
One of the SCC citations.
It's not required. We may not,
Not required.
may not
I'm
refer
not
to those
disputing any of the
decision in
provision.
view of the fact that Dr. Majika doesn't follow certain proposition.
Well, henceforth, I'll keep it in mind to give SCC citations. So it's easy.
That's not required right now.
My lord.
It's time court will dispose it today, and if not, then we'll just pass it.
Much better.
Highly obliged.
Item number 3.
Obliged.
Please, Your Lordship. Your Lordship, service has been completed.
Your Lordship, we are entering for appearance on behalf of respondent number 2 to 11.
This is what matter it is?
It's a quashing matter, Your Lordship.
Quashing of FIR.
Yes, Your Lordship. And the GR case pending in the learned trial court, Your Lordship.
No appearance for the state again. Okay. See, madam, take note of matter. This is happening
We
repeatedly.
took note of it today, my lord.
Probably yesterday also it happened in
Lordship.
3 matters. There is no representation.
Lordship.
Of course, this court at the very fast is would not like to pass any order, but then if it is continuous, then you have to pass some order and
Steps-
forward it to
Lordship.
the lord.
Steps are being taken up today, Lordship.
Kindly instruct your panel lawyers whoever
Lordship.
instructed with
We're taking steps today, my lord.
Please. This should not be.
Unrepresented, Lordship.
Yes, what is to be done?
Your Lordship, we have no objection to.
What is the matter about?
Your Honor, the petitioner has filed. Your Honor,
Quashing of what FIR? What is the allegation there?
Your Honor, the petitioner has withheld for 13 months supply of food supply to the respondent number 2 to 11. However, last year in the month of October, we have come to a settlement. We have no objection to that.
These are non-compoundable offence.
Yes, Your Lordship.
What is the charges under what section of
Under
IPC?
Section 7 of the Essential Commodities Act.
Can you let it come up for hearing then?
Lordship.
Because the government advocate is also
Lordship.
absent. How many private respondents are there?
There are 10 private respondents, Your Lordship.
And you are representing all the 10. Okay. Just say MS. What is your name, please?
Ms. ZSL Sindram, Your Lordship.
MS Syndrome. Council has entered. Appearance on behalf of the respondent number 2.
2 to 11.
11. Today. We'll say that he will take instruction and then we'll have it posted for hearing. And place for grant of some time for taking necessary instruction. Prayer allowed. List after when shall we have it?
Will it be 3 weeks, my lord?
2 weeks, Your Lordship, because the matter in the trial court is on the next
List
month.
Much obliged, Lordship.
Highly obliged, Your Lordship.
Hearing item number 4.
Yes.
Yes. Lengthy matter, Mr. Paul?
Small issue, my lords.
Small to you, may not be small.
No, very small issue, my lords. I will not, had it been, my lords, a little long, I would have said. My lords, even without really getting into the facts, I'll just narrate, my lords, what is the issue. My lords, what had happened is, there was a proceeding before the Deputy Commissioner, insofar as the petitioner's land is concerned, situated in R&R colony. There were proceedings initiated by the Deputy Commissioner, my lords, where we appeared and we pointed out
under the Land and Revenue Regulation.
Regulation. We pointed out that the authority under the regulation would be the Commissioner, my lords, and the Deputy Commissioner is not authorized to pass any orders in that. That plea, my lords, did not find favor with the Deputy Commissioner, and my lords, that was rejected. Against that, my lords, we went before the Board of Revenue. Unfortunately, my lords, the Board of Revenue, without deciding the issues on its merits, whether, my lords, the objection that was taken by us on the issue of jurisdiction, they go on to the issue that whether you have locus or not. Even though, my lords, it is my land on which the patta of my land is to be
But
cancelled.
then the proceeding was initiated against whom?
Against me.
Then where is the question of
locus?
No, no. Locus means this is they themselves have drew a proceeding against him.
They drew up proceedings against me, my lords. They issued notice to
And then
me.
subsequently they ask your locus.
They raise the issue of locus, my lords, and the revenue board decides the entire matter on the issue of locus, says you have no locus to prefer an appeal before us.
Then what for the proceeding was initiated? And proceeding should have been dropped.
My lord, what my lord will kindly come to page 51, my lord.
There's the order of the deputy commissioner.
Yes, the order of the deputy commissioner. Let me read page 51, my lord. Last two paragraphs.
What for it is pending so long, Mr. Paul?
My lords, here there were some ancillary proceedings filed, my lords, by
The complainant
original
in the meantime
complainant.
has expired.
Complainant
And
expired, my lords.
Attempts were made to substitute the complainant, which was rejected by the court. Then
Yes, insofar as this, the original complaint is concerned, my lords, that abates. Otherwise, also, my lords, matters of title have to be decided by a civil court. Irrespective of all that, my lords, here the limited issues, what I just pointed out before, lordships. I don't know what my friend wants to show.
so my lord will kindly come to page 51 of their petition.
Yes, definitely we are this petition. Page 51, yes.
51. After going through the submissions and documents placed by the parties and Rule 26 of the Settlement Rules and Section 315 of the Meghalaya Interpretation and General Clauses Act 1952, the court is of the opinion that it is well settled principle of law in Meghalaya that the power of Commissioner and Secretary Revenue Department Government of Meghalaya shall have the power to confirm or cancel all the settlement in its division, which may consist of a number of districts, and Deputy Commissioner of a district, after following due process of law, refers the matter either for confirmation of the settlement or for cancellation of the settlement done in the district to the Commissioner and Secretary of the Revenue Department. This being the settled law principle of law, I am of the opinion that the plea of the opposite party, that is the petitioner herein, is not maintainable and hence it cannot be considered. Moreover, OP Sri Ranabir Chaudhary has not been able to prove his identity
This is
and
Ranabir
relation.
Chaudhary means
Our advocate.
Advocate, well, let's
This is there. Whether this matter is released by any other bench.
It was earlier taken
Not
up by
released
justice,
per
not
se, my
released.
lords. The matter was originally heard by Court 3. Of course, my lords, with the change of determination, I think it has come.
Let's take it up before any other. This, if it is Ranabir Chaudhary's matter, this court may not be very. This court had quite close relation.
I some difficulty.
See, like proceedings, you do not know which way you have to pass order. You see. This is matter before any other bench. Oh no, there is already two these things. There
Yes.
are already. It has been noted without Mr. Justice. Just thank you, Mr. Justice.
Justice, thank you as reviewed. Court 3, my lords, was hearing the matter. Justice Dingdo has, as a matter of fact, some effective
notes
orders
made
have
on
been.
the top of the file says without Mr. Justice HSTQ and without Honorable Justice Mr. W. Dingdo. And that is probably
Justice Dingdo, my lords, has passed effective orders in this matter. I am just checking the order sheet, my lords, if there is any recusal.
there is any.
Where's that order? This one? Well, it's the last order was passed on 21/10/2024. This matter was actually heard at length by Court 3, my lords. Justice Dingdo, I don't think it's passed.
No, it's not accused.
Not that we are aware of, my lords.
This is a different matter probably.
No, my lords. This was a miscellaneous application filed in this case.
For substitution of the complainant.
So that order was passed, rejecting the application.
Okay, this is a rejection of imprisonment.
My lords.
No, just would like to see.
My lords, there is no order. Last order is on 5/12/2024, directing listing of the matter after vacations. After that, I think the matter has come before my lords.
5/12?
5/12/2024, if my lords kindly have a look.
This order sheet has become so voluminous.
That is the last order, my lords. It's passed by Honorable Justice Dingdo. After that, the matter has come before you, my lords, on 30th January.
So there is no order of recusal.
There's no
right?
order of recusal.
Then why it is here?
This is actually also, I don't know.
Why it is? There is no order of recusal. Okay, just take note of this and inform. Yes, list this matter before any other bench. Just take it back. You take. Just move it.
Item number 15.
Oblige.
Yes.
Your Lordship, I need that this matter come after 1 week, Your Lordship. The conducting counsel is facing some difficulties. You have left the premises.
Service matter.
Yes, Your Lordship. Promotion.
Yes, Dr. Mojiga. Oh, next week? Next week already? One week, there will be. After 2 weeks?
After 2 weeks.
We'll have it after 2 weeks then.
Yes, Your
Dr.
Lordship.
Mojiga.
Right.
Yes, spread for why. And just on the prayer made by MS so and so. H3.
Yes, Your Lordship.
United Council appearing for the petitioner. This is matter of 2 weeks.
Item number 17.
Yes. Mr. Upadhyay.
Lordship, these matters, two matters are connected. Yes, it will take some time, Lordship. So if it comes up next week or any other date.
Next week there is no slot.
No,
Probably.
any other as per the convenience of the court. Yes.
I'm here, but after 2 weeks. Possible. Just see the slot. You say like too many should not be there. Sometimes it happen one day you have so many cases and one day. This also had the request made on behalf of the petitioner list for 2 weeks.
But you argue that because you're taking too much of time in this matter. For me
No,
also
I am here
reading again and
on
again.
the
because
last date
different.
also, Lordship, and today also I am here. And previously, I had taken that time because one matter has reached up to Supreme Court. So,
then sort of make sure on the next day we take it up.
Next.
Item number 19.
Right.
Lordship, there is order for producing the record, Your Lordship, on 28/08/2024. There's some records supposed to be produced. Then whether the record has come.
What records? Who is to produce the records?
This GHD supposed to. There is order 28/08/2024.
28/08/2024.
Yes, there is.
Yes, Mr. Day. You are supposed to produce the proceedings of PM.
I'll produce, my lord.
You have with you.
At present, I don't have, my lord. Just give me 2 days time, my lord. I'll produce it. Probably they have sent, my lord. I just see, my lord, whether there's this record, specific record is there or not.
What is the dispute about? What is the matter?
The issue pertains around condonation of a delay of, my lords, 3,590 days. Records, my lords, may not per se be necessary.
Condonation of delay
In
by whom?
referring an appeal by the petitioner, my lords, before the CM of 3,590 days. Was there any power to condone delay? That was whether it was provided there. Limitation Act will apply before the proceedings. Will not apply. Limitation Act per se will not apply. Before the proceedings. So if there is no authority vested to condone delay, then in such a case, even 1 day's delay also cannot be condoned. Probably there are decisions we do not know. There is, if I'm not, your lordship's right, there is. So what for this record is necessary? Anyway, forget it, since there is an order. Just say as per order dated 28/2024. 24, the learned counsel for the GGDC was required to produce the records of proceeding before the EM in charge, just I stroke is just say
Revenue.
and CEM before this court for proper adjudication. Mr. Day, learned counsel appearing for the GGDC, place for grant of some more time for production of the said records. We are allowed list after
2 weeks.
Lordship, 2 weeks. Lordship.
After 3 weeks.
2 weeks.
You want 3 weeks?
2 weeks.
2 weeks.
3.
To be okay. Is that all I missed? 2 weeks.
First, Lordship.
Item number 21.
Yes.
Lordship, this is an application actually filed based on the compromise did by the parties, private respondent and the petitioner. There was allegation against the petitioner hearing saying that the private respondents have made an attempt to kidnap, that petitioner has tried to kidnap the private respondent. Now, at the meantime, both the party, private respondent as well as the petitioner, they have come to the conclusion that they don't want to pursue the matter. They have compromise. They have filed a compromise deed, and then they said that private respondent want to pursue the case, and then he said by bona fide mistake he has filed the FIR against the petitioner. That was the compromise petition also is there, Your Lordship, by which I have annexure 2, and then private respondent also is supporting in my case actually.
Private respondents are supporting.
Yes.
How many private respondents are there?
There is only he is appearing for all the private respondent. Mr. Sheikh was appearing, but my learned friend is appearing here. Yes. Private respondent number 4 is Samrat Ali.
What this copies and charge sheet and all was called for? Yes, madam, what for it was called for those? There must be something.
Yes, Lordship. This was called for by this Honorable Court with regard to the stage of proceedings, Lordship. This was inquired into by this honorable court, and we informed the court accordingly, because this honorable court said that maybe if the statement of the complainant could have been taken at the first instance by the court, then maybe the charge would have been dropped at that point of time, Lordship.
Was it something like that?
Something like that, Lordship. That's why the stage of the proceedings was
You were
called
not
for.
the counsel appearing in this matter right from the beginning? Or
Lordship, I was there from the beginning, Lordship.
then if counsels are not sure what order has been passed, then
no specific order, Lordship.
But there was no order to that extent, Lordship. It was just a verbal query from this honorable court, my lord, with regard to the stage of the proceedings.
what for this entire order sheet is placed before this court? There must be some reason for which it was called. What is the punishment for 364A?
Yes, Lordship, I have studied it.
10 years, my lord.
What is the minimum?
I guess it is appendix with wait. Particular.
I'm sorry, my lord. The punishment for this offense can range from life imprisonment to death, along with a fine.
364A.
364A, lordship. Kidnapping for ransom or extortion.
Can it be compromised? Heinous offense.
Yes, Lordship. That's why the
Informing life
court has
imprisonment.
no power to for compromise. But I got your Lordship. But here, Lordship, if we go on the merit of the case, Lordship, the complainant, the main complainant himself has come up stating that due to some mistake he has filed the FIR against the prisoner. Of course, the punishment that is, of course, maybe a life imprisonment. However, that is just an allegation. But then now my submission here, Lordship, since the main witness, the complainant himself, has come up and don't want to pursue the case against the accused person, then even if there is a trial, then he may not support the prosecution case, because it will be there will be less chance for conviction, because he may not support.
May not be a ground for question. The less chance of conviction may not be a ground.
No, however, it will be, and we can for because he's the main complainant. Here is only sole complainant. He has come up before the court, and he has make it in his statement that due to some mistake.
What authority you are holding? The Supreme
Yes,
Court?
Lordship, I have.
Not that Gyanching and all. What is the latest?
I think actually not having, but then.
No, we need the latest decisions, because there are some decisions wherein the ground what you said just now was taken into consideration for this thing, that if the trial proceed also there will be no chance of conviction.
Yes,
But later on I think that view has been somewhere diluted by some other decisions.
Lordship, there's no bar for them to come under 482, but by way of a compromise, Lordship, compromise deed, Lordship, I think the
No,
courts are quite,
there are decisions.
Lordship.
Right from Gyanshing is there, then 2019 also is there. State of Madhya Pradesh. What decision you are holding? Just show us. Does it speak about
Yes, that is
heinous crime?
part 35.
Heinous crime.
Yes, it is 302. I think it's a murder
It
in
is
the
not
murder
reported
case.
anywhere. This is not reported anywhere. Narendra Singh. Narendra Singh has been reported in 2012 or when? Why don't you give us a SC citation? These are all reported cases. Why you are not giving us the SC citation?
This is a Supreme Court. Lordship.
It doesn't understand this is a problem.
Or reported. Yes, yes. Reported, yes.
This is reported. This is reported in SCC. Give us the concurrent citation and all. Instead of giving this, loose printout, that also from which thing you have taken, nobody knows.
We'll get a proper citation.
Narendra Singh, you see, after Narendra Singh also there are many judgments. Yes, madam, what do you say?
Lordship, like I had just mentioned, Lordship, they can approach this honorable court by 482, but whether they can by a deed of compromise, my lord, that has to be taken into consideration.
That can be. Just see that proposition of law. Is any this quashing, the exercise of quashing can be exercised. That is clear. The
Lordship.
FS court has made it clear.
Lordship.
Not in one decision, there are many decisions.
My lord.
Okay. Now, only thing is that the involvement, what requires for this court is to see the offense, the nature of offense involved. Now, if it is too heinous and all, then normally power of quashing in case of compromise would not be.
Lordship.
That is what.
No, one thing, Lordship.
The Narendra Singh case was with regard to offense involving under 307 also, isn't it? What is the punishment in 307?
307. Is maximum 10, I think minimum 10 years.
So there is a huge difference.
Yes. But here, what
Lordship,
may I just
10 years along with a fine and potentially imprisonment for life or death. 307 Lordship of IPC deals with the offense of attempt to murder.
Here, one thing may I just submit, your Lordship, that here the complainant himself is denying the involvement of the petitioner hearing because he said he has filed the FIR due to bona fide mistake. That is a statement.
These are all matters of fact, Mr. Sangma. We may not take cognizance of all those things at this stage. Now, if you say so, then you go proceed trial court 3 section 321. Convince the prosecutor to withdraw. There's the prosecution 3 section 321 CRPC probably, if this court is not mistaken, there's a provision for withdrawal from prosecution.
In that case, your Lordship, that necessary order was allowing
No, you verify the provision first.
Yes.
See, this is a problem for you.
Otherwise, my lord, there is a withdrawing and this saying.
Why should you withdraw?
No,
You may
not-
have a case. This court has not said that you do not have a case.
No, I'm not saying what I'm saying. Lordship, withdraw of the complainant and then coming forward with the compromise, it's amount to be the consequences will be the same, your Lordship, because even if he withdraw also.
What is the withdraw?
No,
You cannot-
if
you
he
cannot-
withdraw his
See, withdraw
FIR.
from prosecution is not your thing. This is the prerogative of a prosecutor, not the parties. Parties cannot go and withdraw. That liberty is not there anymore. At least at this stage.
Here, only one like to submit, your Lordship, repeatedly that since the complainant himself is saying that he has filed this FIR against the petitioner against the accused, see, due to some bona fide mistake, yes, and they are not disputing also. That is the main thing. If that,
Have they filed any affidavit before this court saying so?
No, Lordship.
if they were, there is a,
Do you
that
have
is
any
an-
instruction? What is your instruction, madam?
Lordship, as of now, my lord is already on trial, Lordship. So, my lord, my submission is again pertaining to compromise deed, Lordship, because compromise deeds can be arrived at different kind of crime, but this is a serious crime, my lord. So, whether
That is what you just
whether
check the law. Probably you see what you say. So far as the power of these things, you will probably find that Gyan Singh's case,
Yes.
maybe 2012 and all. Then
Lordship.
thereafter, what Mr. Sangma has produced, Narinder Singh. Okay, then it travel up to, of course, this court doesn't remember. In 2019, you will find the state of Madhya Pradesh versus
state of
Sami.
MP also, and even
Yes.
Delhi Lordship 2021, it's there, my lord.
So if you see, in probably we do not, I do not remember exactly, but then I think the apex court has dealt with that part when
Lordship.
heinous crime is in.
Lordship.
So if you go through that and make your submission accordingly,
lord.
that will be better.
Lordship.
And you come up with
So, Lordship,
the SCC citations where you this printout and all. I do not know why.
One more thing, Lordship, what is following from the Lordship, I think let the private respondent also find an affidavit confirming his statement in the compromise. I think, because it is coming, it's just coming from the Lordship. So I think there is nobody they can file it. They can confirm by way of affidavit
See,
their
so
statement.
so long that compromise agreement is not disputed, I don't think there will be any requirement for doing this.
Yes.
Subject to what the learned PPs of this.
They are not
Let us
disputing, my
see,
lord.
Let us see. And how much law allows you? When?
Maybe after 3 weeks, Lordship, I'll be out of station.
Give that to me. So we'll then adjourn it on your prayer. No. If you do not make any prayer for adjournment, then we may have to proceed with the hearing then in such a case.
Let it be a joint prayer, my lord.
Lordship, 3 weeks will be too long because this is
I'll not
quite
be
pending.
here. That's
If
what I
she's
just
out of
stated to
station,
the court.
then again it will be a problem.
Yes.
So again the adjournment will be.
And they've been
the next
taking adjournments for more than 10 or 11 times, Lordship. I don't know
I'm
why
not
they are
taking-
objecting now to my
no,
3
no,
weeks
no,
prayer.
Lordship, I have not taken the.
Is there on
this one.
record? Lordship,
The
3 weeks,
government
my lord.
bodies have been taking the not a piece.
You also will have to give us those decisions,
Lordship.
citations. When can you do it? Tomorrow? If you can do it tomorrow, we'll take it up tomorrow.
I'll be out of station from tomorrow, Lordship. My leave starts from tomorrow.
We'll just say parties seeking time for preparation, further preparation.
My lord.
That will. Yes, the Learned Council preparing for the parties. Grant of some time for preparing the matter. Prayer allowed, list after 3 weeks.
Much obliged, Lordship.
Much obliged, Lordship.
Item number 25.
Yes.
Your Lordship, I'm entering appearance on behalf of the sole respondent.
This is order, Kalan.
No, Your Lordship, this is for hearing, Your Lordship. They are entering appearance now, Your
Then-
Lordship. It's
Okay.
a little bit late.
Okay, Mr. Then what is your prayer then?
Let this matter come up.
You'll take
in 2
instructions.
weeks. I'll take instructions, Lordship.
Okay. Mr.
I'll file my power before the next
Yeah.
date, Your Lordship.
You have not filed. Anyway, we'll just say you are entering appearance. Okay. Mr.
Elo Samloya.
This court is very poor in remembering names. It will take at least 5-6 months to remember. Learned counsel has entered appearance on behalf of the sole respondent today and prayed for grant of some time to obtain necessary instruction. Prayer allowed. List after
2 weeks, Your Lordship.
2 weeks.
Yes.
Obliged, Lordship.
Much appreciated, Your Lordship.
Done.